Los Angeles. And today, as Allison mentioned, we're going to be talking to you about depositing stock, particularly the increased difficulties in depositing stock over the last couple of years. This used to be a fairly easy process in years past, but over the last 3 or 4 years, it's become a bit more difficult. That's because of some increased regulation that's made it through Congress and to the SEC, including the Patriot Act, the Bank Secrecy Act, some additional anti-money laundering regulations, some fraud prevention initiatives. The SEC about 1.5 years ago, 2 years ago, created its the Microcap Fraud Working Group, which looks into microcap fraud, obviously given hence the name. So there's a lot more regulation and a lot more attention paid to companies, to shareholders, to issuers, to shareholders, and to, more importantly, to brokers in this process of depositing stock. And today we're going to talk to you a little bit about those difficulties and some suggestions of overcoming how to deal with those difficulties. Before we get into it, I'd say there's some general guidelines. The first thing you need to do when you're depositing stock is really talk to your broker first. You have to have an account established, and the company that whose stock you're trying to deposit has to have good disclosure, and you need to have your backup documents all in order. And we're going to talk about those things in order, really, but that's going to be a common theme that we're going to hit upon here. The brokers are going to, and the reason I say talk to your broker first is because these rules are really very quickly evolving or devolving, if you will, in some cases. And the brokers are under increased scrutiny. For example, FINRA Notice 0905 lists the red flags for brokers to look for in depositing stock. And in fact, that notice to the brokers reiterates that the SEC's mandate that they can't brokers can't rely in this process on self-serving statements of shareholders or even their counsel without investigating possible contrary facts to the contrary. So brokers can no longer just accept an opinion or a statement or a certificate from you in this process. They're going to look at all the backup. They're going to look at all the backup documents. They're going to have all the backup documents backup proven to them. And there are certain things, before we get into this, there are certain things that make it tough. Tougher, when you're depositing stock. First, if you're an insider, it's a little tougher, and they're going to look at this more closely. Second, if you're a promoter, an IR professional, a website writer, some sort of promotional writer for securities. Companies that have gone through a lot of name changes and business changes and are getting increased scrutiny. If the stock is in relatively few hands, so it's really too closely held, debt to equity conversions really get looked at closely, and companies where the securities were issued when it was a shell get looked at pretty closely too. So if you're in any one of those groups, really pay attention. These things could take a lot longer. So turning to the first slide, which I've prefaced there fairly in depth, the increased scrutiny, as I said, is increased difficulty in depositing your stock. And basically, as you know, what we were talking about with depositing stock is taking your certificates and depositing them into your account so that they are effectively converted into a non-certificated form. I think, Joe, if I'm not saying that correctly, let me clearly jump in any time. The increased difficulty is due to really there's greater amounts of paperwork due to the new due diligence requirements that I just talked about, Patriot Act, Bank Security Act. Fewer brokerage firms are even accepting certificates. A quick run through on Google and we'll point you to websites from TD Ameritrade and all of the other brokerage firms, and immediately on their websites you'll see that some will not accept pink sheet certificates. Some will not accept bulletin board stock. Some have dollar per share or cents per share floors, 25 cents, 10 cents. So you have to check with your broker first, because there are these increased acceptance requirements, or much more difficult acceptance requirements, and so you have to know what those are. The impact of these increased difficulties means that this is going to take a lot longer. The websites for the various brokerages that I just referred to will let you know that this is a 2 to 6 week process. That seems to be that's the general timeline. And there are going to be increases in expenses, particularly if you're sending in a restricted security. There will be different fees for you, additional and fees really across that vary greatly at different brokerages about how they will help you, whether they will help you, and how much it will cost them, how much it will cost for them to help you get those certificated restricted securities, have those legends removed so that they can be deposited. So before we turn to the next page.
Right. So I think there's a couple other things that I think are important here, and everything Scott said is a good summary of the current landscape. I think what especially the issuers on the line need to know that the regulatory burden, in a sense, has shifted from pre-2008, where it was generally, for the most part, on the brokers, and for some part on the transfer agents. I think the regulatory landscape has now shifted where, all gatekeepers involved in the process, play a very critical role in clearing, this restricted stock and depositing it. And the SEC, just from an enforcement standpoint, is really looking at everybody to be a good citizen, if you will, and a good gatekeeper. So that includes transfer agents, of course, and brokers. It certainly includes the corporate attorney or attorneys who are writing the opinions for the various shareholders. And it also includes the issuer themselves. Years past, the SEC used to be very sort of lax about looking at the company themselves or the officers and directors in their role, because for the most part, sometimes officers and directors are removed from the process. But with this increased scrutiny, a lot of times the transfer agents and even the opinion writers are coming back and getting sign-off from the companies. So they're very important for officers or people inside the company who handle these types of sort of clearance issues when there are questions with transfer agents and broker-dealers, to really pay attention and to have a good checklist or a good system in place, because, like I said, companies are no longer getting a pass on this stuff.
That's right. And it remains. This is an important issue, because it's estimated that there's still about 50 million paper securities in circulation right now, and it's not a very efficient, as everyone knows, it's not a very efficient process, because you can, to sell, you have to find your certificate, submit it to the broker, the transfer agent, establish your brokerage account, go through all of this stuff that we're talking about, and you can lose. Go ahead.
I was going to say, and just to follow up on the fees that you had brought up before, Scott, these increase in fees and expenses, 2 to 6 weeks is what people say. If anyone on the line is experienced in this industry, you will think like I think, that is incredibly long, and it never, nobody wants to take 2 to 6 weeks to deposit stock. But that's what a lot of broker-dealers and a lot of clearing firms are calling for. Now, clearly there's ways to be get this done quicker by having your paperwork in order. And there's also, this whole cottage industry that's popped up, depending on the broker-dealers or the clearing firms, with respect to deposit fees and rush fees and non-DTC clearance fees. There's a whole number of fees that have sort of popped up over the last, 12 to 18 to 24 months. And, Scott made an excellent point earlier saying, know your broker, talk to your broker, discuss these things with your broker, because the better relationship you have with your broker, and the more money you have in your account, and you're a consistent customer who doesn't quote unquote get in trouble, that'll likely ease the deposit and clearing process, and you're likely to have a little bit easier time.
Right. Guys, that's where I was going to jump in. This is Brian Herman from ViewTrade, and if you put yourself in the broker-dealer's shoes, it all comes down to know your customer. So when we're reliable for things like the Patriot Act and anti-money laundering rules, and a new customer comes to you and says, I've never done business with your firm before, but I acquired this security and here's how. I want to sell it. I want to close my account and get a check. 5 red flags just went up. So it's really about establishing a relationship with a broker-dealer and realizing that that broker-dealer, ourselves here, in-house, we want the relationships with the customers, but we really want the relationships to last. So it's know your customer, know your broker-dealer. We have to know your line of business. And it's once that information channel is open and the red flags are answered and they've been put down, it's always a smart idea to keep the assets in the account because then the AML flags don't go off. And that's just, I just thought I would chime in there at that juncture.
Yeah, that's right, and as I'm sure you will say, maybe say later, when you're establishing this account, if you have, as he said, if you don't have an account already, or if your account only has restricted securities in it, or only has penny stocks in it, you're going to get looked at a lot more closely. If you have an account with higher value securities in it, with larger, more vanilla securities, if you will, then if you also happen to have some restricted securities in it, then you're not really going to get as close to scrutiny as you would otherwise. But let's talk about now how you can set yourself up for an easier process. Maybe make it be closer to 2 weeks than the 6 weeks. And that is have all your, in addition to talking to your broker and having a good relationship with them, but in establishing your account, even if you have all of those things, you're going to have to help your broker out, as Brian said. So what do you need? What backup documentation are we talking about? And we're really talking about now restricted securities, which is when this comes up. Privately, securities purchased in a private offering, either in a restricted private offering, an offering that was not registered with the SEC, a Reg D offering, things like that, or securities that you received as an employee, as a consultant, in some ways like that. Some way like that was not registered in an IPO or some large secondary or other offering. So what you're going to need is the purchase agreement. How did you acquire these securities? There's going to be some evidence of how you acquired these securities: a purchase agreement, a subscription agreement, something like that. And don't just leave that in your drawer. Have that with you. The proof of the payment of how you paid for these securities, the cancel check, and evidence of the wire transfer. What you're trying to prove here is that you're not one of the relatively rare, but still enough to be a problem type of transaction where securities are given away, or cheap stock, or something like that. That's a problem under some of these rules. So so gather up how you paid for the stock. Now, if you did get the stock in for services rendered, then you'll need the evidence of what your employment or consulting agreement, the evidence of that employment or consulting agreement, and how can you show that you were fully performed? Is there some evidence or confirmation from the company that you fully performed and that your contract is over, or that whatever services that you provided have been, even if you're still in contract, have been provided so that you've earned the securities that you're trying to sell. You'll want to leave. You'll need that. Go ahead.
No, go ahead, Scott.
No, Joe. Go ahead. Before I get to
I was just going to say that. Yeah, I was just going to say that is all of those things are necessary, and it's generally a good idea, especially if you need to get the legal opinion first, and Scott will talk about that in a second, but it's generally a good idea to write a quick summary of how you acquired the shares, or a little bit of the background about acquisition and about legend removal, and send that to either the attorney writing the opinion or the broker-dealer, to have some context when they're putting it through the clearing firm. It goes a long way because, a lot of times, and Brian, you probably see this all the time, you'll get something that's just dropped in your desk with a purchase agreement and a certificate, and, you can't make heads or tails of it, and it slows down the process, and that's probably where we, stay in that 2 to 6 week period. It creates, other issues And quite frankly, everybody's busy. Nobody has time to sort of sort through your paperwork. So the easier you can make it on the gatekeepers, the company, the transfer agent, the brokers, the attorneys, the clearing firm, the better off you'll be.
I would call it the follow the bouncing ball email or statement, follow the bouncing ball from day one, and a timeline. Just going back to if it is consulting shares, again, just to be repetitive, the consulting agreement, the services performed, a summary and attestation from an officer of the company that everything was satisfactory. Just the more information, the better there, and just a timeline. And it just really, from A to Z spells everything out, so there's not a week of just questions back and forth, where was everything disclosed. So you can even put links to the appropriate SEC filings and other documents of all the disclosures of your work and what's been performed or your investment into the company. Copies of, just the documents attached with the timeline goes a long way. And it simplifies things and speeds it up.
Yeah, and I would say, especially with respect to these convertible debt to equity issuances or transactions that are very common these days, that for sure there should be a reference to the financial statements, because unlike an investment, a lot of times that might not be listed, might not be listed individually on a company's financial statements, whereas more than likely a note will be referenced in the financial statements, and maybe it's aggregated, maybe you have to speak to the company, but certainly on the debt to equity transaction, referencing the financial statements will speed things up a lot quicker, because that's one of the first red flags. I mean, even when we write legal opinions, first thing we want to know is this debt valid? And we don't even get to the next step, or we don't really care about anything else, because we don't want to waste our time if there's no proof, so to speak. So with respect to the debt to equity transactions, which are a real hot button, financial statement disclosure and pointing the broker dealer or the transfer agent or the attorney in the right direction is I think a critical first step.
That's right. And as we were mentioning here, helping out your broker. And if you're an issuer, helping, when your shareholders or management is trying, or whomever is trying to do these kind of things, you'll be able to know to be able to help them out. So if you're a shareholder and you're trying to sell your shares, you got to help your broker in the way that we're talking about. You also have to help your one of the primary documents or due diligence documents for everyone is the legal opinion. Now, you're going to have to help your lawyer as well by providing this bouncing, where's the ball bouncing memo and backup documents. I recall several years ago in drafting these sorts of opinions while I was at Pillsbury, which is the large law firm, they were literally a half a paragraph long. I mean, 2 or 3 sentences long. That's it. Now, an appropriate legal opinion for a 144 legend removal is several pages long with several exhibits, or at least reference to several exhibits specifically, what they are and the date thereof and what the exhibit is. You really, if you're getting an opinion from a lawyer that's giving you a half paragraph opinion now, it's maybe it clears, maybe it goes through, but you're really increasing the risk and you're setting yourself up for that's a potential issue. Because as I mentioned before, the brokers, FINRA has told the broker that they cannot just rely on self-serving statements. They cannot just rely on an opinion that says, no, it's okay under 144. They have to do their backup. They have to do their backup, have proven to them that there are no contrary facts. So if they get a legal opinion that says, hey, I looked at A, B, C, and D. I looked at the purchase agreement. I looked at the financial statements. I looked at the officer certificate from the company. I looked at from the broker's rep letter. All of the elements that are required from whatever rule it is to issue the legend removal opinion, whether that's Rule 144 or 4.1 in the Securities Act. The opinion will go through all of the prima facie case, if you will, of why the legend can come off, not just the conclusion of that it can come off. That will help the broker out. So it's a due diligence function. You have to think of the legal opinion as a due diligence function and evidence thereof, not as a legal conclusion, not only as a legal conclusion.
Yeah, and to follow up on that, it's a really good measure. I mean, to get a good legal opinion, like Scott was mentioning, one that goes through not necessarily a full recitation of the facts, but at least has a summary paragraph references, a stock certificate, and then not only mentions the backup documents, but even in our case, we attach the backup documents to our opinion. One, it makes the process a lot cleaner because everyone can see, the entire history of the transaction. They're all right there. But really, the most important piece of that, of getting a credible legal opinion, is that it really protects the issuer, right? Because a lot of times the transfer agent calls up the issuer and says, hey, are these shares good? Or a lot of times the transfer agent goes to company counsel and says, hey, do you approve of this? Right? So it's putting various gatekeepers in awkward positions when they may not be the principal author of that legal opinion or are principally involved in the transaction. A good measure is for the issuers, all the officers and directors, listening to this webinar, is by getting a good legal opinion. It's not a get out of jail free card, so to speak, but it does give you some comfort that at least for the corporate file, when they come and say, hey, is this good, there's a very solid due diligence document, in the file for, for the company and for the officers and directors, and of course for the shareholders and everyone else. It's just a very nice way to cover yourself, especially if there's a lot of restricted securities coming off, coming off legend and entering the marketplace. Because, like I said, officers and directors are no longer immune to this process. You can't hide your head in the sand and say, hey, I didn't know the legend was coming off, because everybody is very active in bringing the company into this process nowadays.
That's exactly. And there may be some additional, going to the next slide, the clearing firm, the attorney, the transfer agent, the broker could ask you through this process for additional due diligence. I mean, they'll slow the process, but it does help. It does help get it done. The faster you comply with these, with filling out the KYC, the Know Your Client, or giving the backup document for the legal opinion. That's going to be the faster you do that. It's like, I hate to say it this way, but it's like dealing with the IRS. If you fight it, it's going to take longer. So if you want to be on the 2-week side instead of the 6-week side of this time estimate, then you just have to be prepared and do it.
And for officers and directors, I really encourage, we do this with all of our clients. I mean, we create a lot of compliance checklists for our companies, or even for certain investors that we represent, but mainly for officers. You should have a very short checklist that you run through every single time when someone's going to free up shares and you get that call from the transfer agent, you get that call from your attorney who's asked by the transfer agent to, hey, do you approve of this opinion if it's written by someone else, just to protect the company, because again, it's the company's securities, and the regulators are always going to look back to the company and what you knew and how you knew it and what you did and were you a good gatekeeper and were you a good citizen of this community, and to have a good small checklist just to run through is incredibly helpful, because especially if there's a lot of deposits being made on the company's stock.
Right. Let's go to the next slide, issues with depositing. As I said, as we mentioned before, and we'll reiterate a little bit more, lower price securities, pink sheet companies, if you're an insider, if you're an IR professional, if you're converting debt, all of those things are going to be looked at more closely. So those are the kinds of securities or holders that really have to be much more diligent in coming up with your backup documentation. Now that's a broad topic, and probably it's true to talk about everything that each one of those would need is a bit more time than we would require. Just know that those categories, lower price stock, pink sheet stock, bulletin board stock, large blocks of a thinly traded stock, all of those kinds of things, which really do follow sort of a common sense. It's very common. It's very much common sense that those would be something that the SEC would be concerned about. You're going to have to talk to your broker, give it a little more time. Talk to your lawyer, talk to your broker, and make sure that this doesn't get held up. The more prep you do in the beginning, the better.
And I will just add, that's an excellent point, certainly preparation and certainly due diligence. But I think, there's a bigger point here that I think everyone needs to sort of understand. And I said this, I had spoken at another seminar a few weeks ago. It's very important to understand that the process is just as important as the actual result. And what I mean by that is, everybody here in this industry is charged as being a gatekeeper, and everyone has, collective and individual responsibility. But if something does go wrong, and invariably something will go wrong, right? Something slips through the cracks. It's much better to have engaged and gone through a very thoughtful, careful process for clearing your certificate. Even if you're wrong, you thought Rule 144 applied, it got by everybody, you're using a 4.1 exemption, maybe the time frame wasn't long enough. That might not ultimately save the day, but it looks a heck of a lot better to somebody looking at this transaction or reviewing this transaction that was deposited a couple years from now, when the person depositing it and ultimately selling, went through a very detailed process and had a good backup file, as opposed to sending a certificate, a purchase agreement, and an order that says, "Rush, please deposit and sell immediately." So just keep an eye on the process that everybody goes through, in addition to the actual result, because it will help ultimately if something does go wrong.
Do you want me to start on the last two slides over there?
I think you can, Brian, if you want. Sure.
Okay.
Yep.
Pretty routine, just in the process of opening up an account. Just keep in mind, highly regulated at the brokerage firm level, and the new account documents are going to be checked, and the I's are going to be dotted, and the T's are going to be crossed. Keep in mind AML and background checks and the customer information, the CIP information, which all comes around knowing your customer, proving who they are, picture ID. Keep in mind that the brokerage firm will do a background check. They're required to run you through a background check. So I would just advise to be upfront with full disclosure, knowing that the background checks are going to be done. They have to be done. And if there's anything on there that you want to explain rather than a defensive posture, just have a written statement prepared. So be upfront, full disclosure, have a written statement prepared. If something does come up on the background check, only the customer would know that, and that way you're not in a defensive position in dealing with a compliance department on the account opening process. That can delay things as well. Let's see. And depositing the securities, I think we've pretty much touched on all of these topics. As far as every firm will have their own procedures, so it's not one cookie cutter, one size fits all. Everyone will have their own depositing securities questionnaire, and they're very detailed, they're tedious, and you have to answer all the questions. So just keep in mind that every firm will have their own procedure and their own questionnaire to fill out. But the nuts and bolts, the mechanics of them, they're all the same. Have all of your documentation, have a timeline is highly recommended to have, along with your proof of payment and the proper disclosures. But again, I think we're beating a dead horse. We've been there on this call. And that sums it up there. We've touched on everything.
Yeah. Maybe we can talk about real quickly. Want to talk about the fees for the process?
Sure. I mean, and there, along with every brokerage firm having a different questionnaire, and every clearing firm having to agree with that questionnaire, so your paperwork's going to be different. If you're lucky enough to have an account at Fidelity where you have enough assets in it, and they're going to take your shares, their questionnaire is going to look different than ViewTrade's questionnaire. So as far as the fees, you would have a normal processing fee for depositing restricted securities, certificate deposit fee. The clearing firms will normally charge a 144 legend removal fee. Of course, there's going to be overnights back and forth to the transfer agent. Some firms will pass through the transfer agent fees to the customer. So again, to try and summarize and ballpark and guess, sometimes it's on the low end a few $100s, and on the high end, I've seen somebody aggregate $1,100 for a certificate deposit, and that's a transfer agent reject, and not having your paperwork in order, and just the time involved. So
yeah, you can definitely. I think you can. The takeaway there is you can definitely make it be more expensive. You're not necessarily going to be able to get out of the base fees that the firms will have, but you can definitely make it more expensive for yourself. Same thing applies in terms of a legal opinion. Legal opinions will go anywhere from a couple $100 to several $100. And what I'd like to say about the legal opinion, though, is you really do get what you pay for in terms of a legal opinion. You can certainly go out, even today, despite SEC action against attorneys who are issuing these kinds of opinions, you can still, to this day, go out and potentially find an opinion for a couple $100. But those are the opinions that will be problematic. It shouldn't cost you $1,000, but it shouldn't cost a couple $100 either. So.
And I think
so really,
I think just on legal opinions, just to follow up on legal opinions, I think that's absolutely right. And remember, a legal opinion is not a foolproof way to protect yourself or, like I said, a get-out-of-jail-free card. But it is a very good way when you get a proper legal opinion with the proper attachments and the proper backup analysis. It really does protect you as the holder. It certainly protects the companies. We have a number of companies that we just act as special counsel for, and we write opinions, and we don't even do the regular work. It's only because the company and the officers and the directors don't want to have blowback on on them, because ultimately it's the company's securities. And again, a good legal opinion will cost you $400 or $500. More complicated ones could be slightly more expensive. But again, it's a great insurance policy to have for the file for all of the gatekeepers involved in the process.
All right. I guess let's see. Do the DWAC and FEST process. Just briefly, DWAC obviously is the deposit withdrawal custodian, as what it stands for, run by the DTC. Basically, this is the electronic method of transferring shares between brokers using the DTC and the transfer agent as the custodian. Forgive me for that background noise. This is a process that takes a couple of weeks. If you don't already have your shares DWAC'd, it takes a couple of weeks to get done. This really allows the shares to be electronically transferred between brokers, as I said, so it can be faster after you do that.
Yeah, I think if companies are eligible for this process, you should go through the couple-week process to get DWAC eligible. Sometimes it can be quicker. I don't believe it's very expensive. It's not like getting DTC eligible. But what it really does is it allows, for the most part, allows the transfer agent to almost immediately and electronically transfer, your securities to your broker. It generally is a lot faster and likely a lot cheaper. Although depending on who you use, that could be up in the air. And Brian, you may have some thoughts on the DWAC process.
From the industry's perspective, cheaper, easier, faster, more convenient for the customer, more convenient to track, less paperwork, all of the above.
Right. Okay. Well, Brian, do you have anything to add from to the process before we turn it over to Q&A?
No, it's just it's a matter of supplying the broker-dealer enough information to feel, to be able to vet each customer out, and just how thorough and how upfront and how disclosed your information package is at the time of delivery. More information is better, clear, concise is better, and you probably want to have a good handle on the paperwork before you try and deposit it at the firm, and you will have much less problems.
Right. Okay, Allison, we could open this up for Q&A.
Well, thank you, all of you. And we do have one question to start with. Does it help if an issuer is on a higher tier of the OTC market, OTCQX versus OTCQB versus OTC Pink?
From a broker-dealer perspective, I would say the higher the tier is always assuming the higher the quality, and you get, I don't want to say less of a review, but it's, if it's a NASDAQ-listed company, a lot of times there's a lot of parts of the questionnaire that do not apply, and you're answering less information. To where if it is a lower tier OTC BV company, you've got much more information to fill out, much more questions to answer. And from that perspective, the higher the tier, the higher the exchange, sometimes even the larger of the issuer, the easier it is to fill out the paperwork, and therefore the process is shorter.
Yeah, and some brokerages will not even take the any of the pink sheets or lower tier. Just won't even deposit it. In fact, and then if you're on the pink, if you're on any of the, if the company has the stop sign, yield sign, for some problematic issues that you're not going to be able to, you may not even be able to deposit them.
A good rule of thumb is you want to try to. From our level, from a brokerage firm's point of view here, this is Brian at ViewTrade, is the issuer must be fully reporting, fully transparent, and have access to publicly available, accurate information. So the fully reporting cutoff, and then of course the higher the tier, the better. But from there, sorry.
Yeah, and from a legal opinion perspective, which is obviously very necessary throughout this process. The more transparent, meaning the higher the tier, the easier it is and the cheaper it should be to get a legal opinion. We get requests all the time from people who come and say, "Hey, I got this cert, I got it." We look it up, and it's a stop sign, no information. I mean, there's just no way to diligence that from a legal opinion perspective without having to, do a lot of homework and drive up costs. So clearly, this goes back to getting your transaction documents, in order, also for the legal opinion. But the higher tier, the cheaper the opinion.
Right. Okay. Any other questions?
We have another one. It says, what about the requirement that the company be current to lift a 144 restriction? Does that then increase the legal fee?
Well, I think if the question is an opinion for a company that's not current more expensive than an opinion for a company that is current, the answer, at least in my view, is yes, because there's just more risk and more work associated with that opinion. But if they're current and they're just waiting to make a filing because they're late for whatever reason, I don't think an opinion can be written until they get current, and at that time it should be the same cost as if it was, current all along, as long as it's current.
Sure. And then, sorry, did someone have something to add?
No, go ahead. Next one.
Okay. Can you just touch briefly on the eligibility requirements for DWAC and FAP securities?
From the, I guess, from the company's perspective, is that what the question is?
Mm-hmm. Yeah.
Yeah, I think I don't know, per se what all the requirements are. The transfer agent will know a lot better, but clearly there's a diligence review done, by the DTC and by the transfer agent before, DWAC will be allowed. So I would say follow up with your transfer agent. They will have a better checklist because they're the ones who really handle that process. But the cleaner the better, and the more that you have your company house in order, and the more that the transfer agent is familiar and comfortable with the way the company has issued securities and removed legends in the past, clearly the better.
Okay. Is it common or appropriate for the issuer to lead the preparation of documentation and complete the process on behalf of a shareholder?
So are you asking, can the company complete the paperwork for the shareholder?
Yes.
Yeah, in my view, I don't, as a securities attorney, I don't have a problem with the company assisting its shareholders with tracking down paperwork, especially, it happens all the time where people give money to the company they're participating in offering. They don't know what signature pages, where they are, they've changed computers, they've, something they moved, whatever the case is. So I don't have a problem with my clients helping or assisting the shareholders on a legend removal, except for the following case. I think that it's a pure equity legend removal or a pure conversion that the security was convertible by its terms, I would say not a problem. But I think all the officers and directors out there need to be very careful when you're talking about convertible, debt to equity transactions, especially among third parties, and when these instruments have transferred, from non-affiliate to non-affiliate, and then somehow, get converted and sold into the market. I would just say be very careful, because there is this sort of overarching principle out there that the SEC has kind of been invoking more and more lately of, having too much involvement by the company could somehow taint a non-affiliate transfer, certainly on the debt to equity conversion side. So you just want to be careful. If it's an age certificate and you have 10 securities, 10 investors coming off Legend at the same time, and they just don't want to be bothered, not a problem. But if it starts to get more and more complicated with this third-party non-affiliate and debt-to-equity stuff, I would just say be careful, because you wouldn't want someone to look at that transaction a few years later, without the context, and say, well, this was just a company sort of shuffling around its securities and sort of tainting that non-affiliate status. That would be my only caveat.
Okay, and then we have one more question. Assuming that we're talking about a non-affiliate, is it easier to deposit securities that have been held 12 months or longer?
Brian, you may have some thoughts. I'll say from the legal end, clearly, the longer the holding period, the better. And that really is going to depend on whether the company is reporting or not reporting, and whether it's ever been a shell company. One of the things we didn't really talk about today, and it's kind of a whole other topic, but, and I'll just quickly put it out there, but, Rule 144 is the safe harbor provision that everyone relies on, that, if you meet these objective requirements, you can not worry that the SEC or anyone else will accuse you of, distributing the company's securities or becoming a statutory underwriter, all those things that you need a registration statement for. With the new rules that came into effect in February 2008, this sort of provision of Rule 144I, whether you're a former shell company and if you have to hold the shares for a year or longer, sort of have come into play. So what we're seeing a lot is, people have been requesting, 4-1 opinions, which, would basically was, the precursor to Rule 144, where 144 is not available because the company was a former shell. We've been getting requests for 4-1 opinions going back to sort of the old rules, like the 70s and 80s before Rule 144, saying that, the holder is not a statutory underwriter and that you can free up the certificate under a different, a different exemption. So in some cases, 12 months is probably easier, but it's just going to depend on the shell status, or history, I should say, shell history of the company, and whether the company is reporting or not reporting.
Yeah, internally with my questionnaires, if it's reporting for over 12 months and the certificate is over 12 months, that can simplify things.
All right, well, that was what we've got for today. Thank you, Brian, Joe, and Scott, and everyone that tuned into the Depositing Stock webinar this afternoon, presented by Pacific Stock Transfer and Edgar for Free. Again, don't forget to visit edgarforfree.com and see how much Edgar for Free can save your company. If you have any questions that we were not able to answer or that come up after this webinar, please feel free to reach out to myself, Scott Klein, Joe Lukusky, or Brian Herman. Thank you again, and have a great afternoon.
Thank you.
Thank you.